much, Leslie, and good evening to all of you. We're looking forward to an interesting discussion on this big idea, thinking big, as this year's Humanities Festival theme is, and it's a real pleasure to be part of the Humanities Festival again. I thought I would begin with just a word about the rule of law and then introduce our panelists to you so that we can see what they have to say about it. In recent years, we have been having a much more searching discussion about this concept than ever before. What does it really mean? Some people think it has both a substantive and a procedural component. From the substantive standpoint, a society that respects the rule of law is one in which open and transparent laws are applied impartially and equally to everyone. From a procedural standpoint, the rule of law requires what Americans tend to call due process. That is to say, the right to notice, to an opportunity to be heard before an impartial decision maker. There are definitions you can find in many places, including from our own State Department, which has a more elaborated version of this. But the ideas remain constant. No one is above the law. There are certain obligations that all citizens have, and there are certain rights that all citizens have. Our panel will be exploring, in their own way, what this concept means. So we'll begin by considering where the rule of law may fit within our broader constitutional structure. We're very fortunate to have with us this evening to launch that discussion, Professor Laurence Tribe, who has given that question, as well as many others, detailed consideration in his recently released book, The Invisible Constitution. Professor Tribe is the Carl L. Loeb University professor at Harvard Law School, where he has taught since 1968. Before joining Harvard's faculty, he served as a law clerk to Matthew Briner on the California Supreme Court and as a law clerk to Associate Justice Potter Stewart at the Supreme Court of the United States. He also served as the director of the Technology Assessment Panel of the National Academy of Sciences. His scholarly works are far too numerous to list, but they include, in addition to the book he will be discussing today, such books as Abortion, The Clash of Absolutes, and one entitled God Save This Honorable Court, How the Choice of Supreme Court Justices Shapes Our History. Professor Tribe has also had a distinguished career as an advocate before the Supreme Court of the United States. He's contributed frequently in congressional hearings, and he has also served as a consultant to the drafters of many constitutions around the world. After Professor Tribe speaks, we will hear from Chief Judge Frank Easterbrook of the United States Court of Appeals for the Seventh Circuit. Chief Judge Easterbrook began his distinguished legal career as a law clerk to Judge Levin Campbell of the United States Court of Appeals for the First Circuit. He then joined the Solicitor General's office, where he served first as an assistant to the Solicitor General and later as Deputy Solicitor General of the United States. In 1979, he joined the faculty of the University of Chicago Law School, where he was named the Lee and Brina Freeman Professor of Law, and where, like me, he continues to teach today as a senior lecturer in law. He too has a lengthy and wide-ranging list of publications. Between 1982 and 1991, he was an editor of the Journal of Law and Economics. He's written extensively in the fields of antitrust, corporate law, co-authoring The Economic Structure of Corporate Law with Professor Dan Fischel, and securities regulation. And finally, we'll hear from Geoffrey Stone, who today is the Edward H. Levy Distinguished Service Professor at the University of Chicago School of Law, where he has been a member of the faculty since 1973. Over the years, Professor Stone has served as both Dean of the Law School and Provost of the University. Before coming to the law school, he too was a law clerk to Judge J. Skelly Wright of the U.S. Court of Appeals for the District of Columbia Circuit, and then for Associate Justice William J. Brennan, Jr. of the Supreme Court of the United States. Professor Stone has many books to his credit as well, on constitutional law primarily, and the First Amendment. Most recently, he's authored Top Secret, When Our Government Keeps Us in the Dark, War and Liberty, An American Dilemma, and the award-winning Perilous Times, Free Speech in Wartime from the Sedition Act of 1798 to the War on Terrorism. Returning to Professor Tribe's book, The Invisible Constitution is part of a fascinating series from Oxford University Press, for which, by the way, Professor Stone is one of the editors, entitled the Inalienable Rights Series. Other books also exist in this series from members of the American Academy, such as Judge Richard Posner and Professor Richard Epstein. Professor Tribe's premise, if I can summarize it very briefly, is that much of what we understand as part of the Constitution does not appear in so many words in its text. Instead, he analogizes it to the dark matter that holds the universe together. So, it is my privilege to turn the floor over to Professor Tribe so that he can explain to you exactly what he means by that and how it relates to the rule of law.
Thank you very much, Judge Wood, and thank all of you for being here. It's a privilege and a pleasure for me to talk with you about my book and about how some of its themes, which you can explore more fully if you read the book itself, how some of its themes relate to the rule of law. Lest I go too long, I want to make sure that whoever is going to be giving these signals is visible to me, okay? Because we want to leave time for questions and answers. A number of friends have asked me how long I have been working on this book, and I would love to have said, oh, just a few months. But the truth is, about 40 years. I have written other things in the meantime. I published a treatise on the American Constitution and a whole bunch of other articles and did some work on other constitutions and cases. But this book has been on my mind, really from the time I began clerking for Justice Stewart in the U.S. Supreme Court. And there was a case in particular that triggered it all for me, a case called Katz versus the United States, decided in 1967, that involved electronic eavesdropping on someone in a telephone booth. You remember what those things used to be? Shows you just how old I am. The government's argument was that the transparency of the booth did not deprive the government of the ability to look at what this guy was saying, could have read his lips. He therefore wasn't seeking privacy, and therefore electronic eavesdropping did not invade anything. And moreover, the law had previously established that to have a search or seizure within the meaning of the text of the Fourth Amendment, you have to have a physical invasion of a constitutionally protected place. The court, on the other hand, ruled, overruling those decisions requiring physical invasion, that what Mr. Katz was trying to exclude when he went into that transparent telephone booth was not the unwanted eye, but the uninvited ear, and that it was a violation of his justifiable expectations of privacy that made this a search and seizure. The problem the court confronted was, how do you decide what expectations of privacy are justifiable? I mean, if it's a descriptive rather than a normative matter, you could have the government put billboards everywhere saying, Big Brother is listening, watch out. There was only a line in the opinion. I tried to persuade Justice Stewart and the court to expand this discussion, but there was only a line suggesting a hint that where you find these justifiable expectations of privacy is not in the Fourth Amendment, but in something that surrounds it. Indeed, in the First Amendment, the court said that freedom of expression in a society that has come to rely in a ubiquitous way on electronic communications through the telephone as it then was, would be unduly shrunk if people had to know that anything they said on the telephone might be overheard by Big Brother. That's what made the expectation of privacy in this case justifiable. So it was a matter of connecting the dots between the Fourth Amendment and its protection of people, places, and effects, and houses, and the First Amendment and its protection of freedom of expression. I hadn't really generalized that into a method at the time. I was only 25. I've been working on it for a while since. But what I've come to think is that much of what's in the Constitution can be best understood by connecting the dots of provisions like the First Amendment and the Fourth Amendment, looking at the line between them, connecting that in turn with something like liberty, forming the triangle, looking at the geometric structure of the Constitution. And I call that the geometric method of constitutional construction. There's also something that I've come to call the geological method. That is, if you ask, why is it that the Fourth Amendment protects justifiable expectations of privacy in some places more than others, for example, in the home, you inevitably, I think, are drawn to the conclusion that it's because the Constitution presupposes an important value in the autonomy of what goes on within the home. Of course, not absolutely. One can beat someone up inside the home and thereby implicate a powerful public interest. But unless there is some special sanctity to the substance of what people do consensually in private within their homes, it makes relatively little sense to have the procedural protections of the Fourth Amendment. That is, one digs beneath the textual protection of persons and homes against unreasonable search and seizure by what I have come to call the geological method, to look at the underlying presuppositions and foundations of what is in the text, what is in the written rule of law. Now, the choice between the geometric method, the geological method, and several others that I describe in the book, I'm obsessed, I guess, with G's because they end up including the geodesic method, the global method, the gravitational method, and the gyroscopic method. But the choice between those methods and a more purportedly constrained linguistic approach in which one looks at the plain meaning of the rule in black and white as written in the Constitution is not left entirely to the imagination, because part of the text is a provision telling us that the text is not all there is. It is the Ninth Amendment, which says that the enumeration of certain rights in the Constitution shall not be construed to exclude the existence of others reserved to the people. Now, that's an important reminder that what you see on the face of the written document is by no means all there is. It's a way of saying there's more here than meets the eye. And even if that language were not there, I argue in the book that any finite document purporting in a purposive way to chart a course for a nation through imposing certain rules and constraints and constituting certain institutions is inherently incomplete. I draw an analogy to Gödel's theorem in mathematics and mathematical philosophy, in which, to reduce an incredibly brilliant and complicated issue to something very straightforward and simple, it turns out that any axiomatic system that is rich enough to include even the elementary operations of arithmetic must include true theorems that are not provable by the methods of the system. In other words, the system cannot fully describe all that is true about it. And I think no finite document can fully describe within its terms everything that one would need to know about its meaning. There are at least two sets of constitutional principles that in that sense are necessarily invisible. There are what I would call meta principles, principles about how to read the rest of the document. The Ninth Amendment is the principle, such principle, in the Constitution itself. It says the enumeration of certain rights shall not be construed in a certain way. It's a direction to you as the reader, whether you happen to be a judge like Judge Wood or Judge Easterbrook, or a scholar like Geoffrey Stone or me, or an ordinary citizen, or a member of Congress, or a member of the executive branch. Certainly all who take an oath to uphold the Constitution are instructed by that language about how to read it. And my first claim is that no set of instructions about how to read a document can be complete. Because if the Ninth Amendment says a certain thing, you might then ask, well, how are we to read that? Judge Bork, when he was nominated to the Supreme Court, didn't do himself much good with the Senate when he said, well, the Ninth Amendment is a mere ink blot. I can't read it. It's too indeterminate. It gives me too much discretion. To which the response of the Senate Judiciary Committee was, it's not up to you to erase from the Constitution something that you think it's difficult to understand. It may sound laughable, but the guy was brilliant and had a point, and it was in some ways unfortunate that his views were caricatured. But I do think that he kind of missed the point that everything in the Constitution, however hard to read, has to be taken seriously, even if what it tells you is there is stuff out there in the dark matter that is not specified in the language of the document. Then there are principles, not just meta principles, but particular principles that we take, most of us, to be constitutionally fundamental, like the principle of one person, one vote, that certainly are not derivable in any way from the language, but that implement underlying values of participatory democracy that the Constitution as a whole is thought to contain. The Equal Protection Clause, for example, is a rather difficult home for the one person, one vote principle, especially when you apply it to the House of Representatives of the United States, where the principle of equipopulous districts certainly can't be derived from the 14th Amendment's Equal Protection Clause, since that applies only to the states, not to the federal government. It can't plausibly be derived from the Due Process Clause of the Fifth Amendment. Hugo Black, in Westbury v. Sanders, derived it, as it were, from the language, the people. The Congress shall represent the people. Well, you can say that there is therefore a textual basis for the principle of one person, one vote, but you'd be fooling yourself. There's nothing in that language or plausibly inferable from it that leads you to the rule of one person, one vote. Or take another principle, the anti-commandeering principle, that says that when the Congress of the United States, even if it's acting within its substantive authority, for example, to regulate commerce among the states, that when the Congress attempts to exercise that power by effectively compelling states or cities to exercise their sovereign authority in a given way, to pass specified laws, or to enforce certain laws, as in the Brady Law, it forced chief local law enforcement officers to do background checks for the federal government when people want to purchase guns. And when the Supreme Court, in a 5-4 decision, says that violates the anti-commandeering principle, it was quite candid about the fact that that couldn't be found in the text. It was, as the court put it, implicit in the tacit postulates of the Constitution. Now, the liberals on the court who dissented from that decision, in effect, accused the majority of making things up because there was nothing in the text that could justify the anti-commandeering principle. They were being hypocritical in making that claim, because there's also nothing in the text that justifies an anti-commandeering principle when it comes to personal life. The principle that there are limits on the ability of the government to take hold of your life and determine how you will lead it, how you will lead the good life, what as a woman you will do with your body when you're pregnant, what you will do in terms of how precisely you raise your children. Nothing in the Constitution says that we have a limited government, substantively limited. And yet there tends to be very broad agreement that that's true. But when the liberals rely on that principle in decisions like Griswold versus Connecticut involving the right to use birth control, or Roe v. Wade involving the right of a woman to terminate a pregnancy, the conservatives are rather hypocritical when they say the Constitution doesn't mention abortion, it doesn't mention birth control. So, of course it doesn't. It doesn't mention states' rights either, or the anti-commandeering principle. And the point of my book is to show that the invisible Constitution is an equal opportunity mystery. That is, it's not simply something that liberals get to invoke when they want to protect reproductive freedom, or that conservatives get to invoke when they want to protect states' rights. It's an intrinsic feature of any constitution, and in particular one like ours, and a feature that we should be debating about substantively. That is, what are the fundamental core principles on which we as a nation agree? I think we actually agree that there are limits not just those specified in the Constitution, on how far government can reach into the bedroom, into personal life, into the body. The reason a decision like Roe v. Wade is so intractably difficult and controversial isn't that that underlying right isn't written down. It's rather that the imponderable task of deciding how much protection to give to the unborn when it limits that right, that task is fundamentally and profoundly difficult. Now, some people take the view that because it's so difficult, it should not be performed by courts. We should have a different rule in each state. It should be up to legislatures. And there's a vast literature debating that, but that's not the subject of my book. My book is not about the question of when courts should intervene, because even if, hypothetically, we took courts out of the business altogether, remember the Constitution speaks not only to the judiciary, but also to the legislature. And if you were a lawmaker asked to pass a law that said women cannot drink more than 1 glass of wine a week when they are pregnant because there's a fetus inside, you would have to ask yourself, even if you were not acting under the shadow of a court, is enacting such a law consistent with the underlying postulates of our Constitution about the limits of government intrusion into personal liberty? Now, it will be objected by many that in sharp contrast to the ideals of the rule of law, this process of inferring structure is far too indeterminate. Well, it's also the case that the meaning of something like freedom of speech is desperately indeterminate. That's why the court divides 5 to 4 on cases like flag burning. The text, in any event, commands, I think, the process of inferring something beyond the text, and that was my point about the Ninth Amendment. Now, among the most basic of the postulates that isn't written down in the Constitution is our commitment to living under the rule of law. And I think you will hear from Judge Easterbrook and perhaps others on the panel the difficulties of that concept. It usually, as Judge Wood pointed out, refers to broadly applicable codified systems of predictable rules fairly and uniformly applied. That's one idea. Second idea is the idea that government itself, the executive, is bound by the rule of law, a principle that is not necessarily implied by the first, but that traces largely to Magna Carta in 1215. Third, there is the idea that not only is the executive bound, but the legislature as well, that the Congress is bound, a principle that was articulated most powerfully in Marbury versus Madison. And finally, there is the idea that one needs an independent judiciary to put teeth in the way the rule of law binds the government, although there are disputes, as I indicated earlier, about the degree to which judicial interpretations should be binding on the other branches. But the rule of law goes beyond these 4 dimensions, and I want to close by suggesting a more positive dimension to the rule of law, and then turn it over to my fellow panelists. One of my favorite cartoons is from the New Yorker magazine. It shows people who look like they're pilgrims on what could be the Mayflower, looking at a distant shore, and one of them says to the other, in a contemplative mood, seeing the land, religious freedom is my immediate goal, but my long-term objective is to go into real estate. Now, the cartoonist's original intent was probably to give a cynical inflection to the American dream and the Constitution's project of securing the blessings of liberty to ourselves and to our posterity. But the hidden structure of the cartoon's caption, I think, lies deeper. It lies in its recognition that negative liberty ultimately requires a positive edifice of law, like the edifice of public law that creates an institution such as private property, and ultimately the edifice of public law that creates the possibility of meaningful freedom. I explored that theme in 1989, and coincidentally, a very brilliant law student worked with me on an article exploring it called The Curvature of Constitutional Space, What Lawyers Can Learn from Modern Physics. He was probably the most impressive law student I've ever had, certainly the best research assistant. You might have heard of him. His name is Barack Obama. And when he takes the oath, some 70 days from now, administered by another very brilliant former student of mine, John Roberts, I think the rule of law will be a bit safer. Thank you very much.
The title of this meeting, The Invisible Constitution and the Rule of Law, starts with the title of Professor Tribe's new book, but the punch is in the rule of law portion. How can there be a rule of law if the Constitution contains invisible clauses, which are discernible only to judges, professors, and other members of the legal elite? Wouldn't it be better to recognize that the emperor has no clothes? Despite the strangeness of phrases such as invisible constitution or unwritten constitution, I agree with Professor Tribe that much of our Constitution is unwritten. Indeed, much of any writing is unwritten, because no text contains its own dictionary or its own rules for decoding. It doesn't take a deep understanding of Wittgenstein and other linguistic philosophers to see that meaning lies in how words are understood by an outside interpretive community, because no text is internally complete. For any modern interpreter of 18th century texts, or even 19th century amendments to 18th century texts, the problem of incompleteness is compounded by the fact that the interpretive community in which those words were recorded no longer exists. We don't think or hear words exactly like people in an agrarian community of 1787 did, and thus can't be confident that how we hear words reflects their actual meaning. Still, we do know that from the outset of the nation, the living interpretive community has seen in the Constitution more than its words. People have deduced from the supremacy of the Constitution over statutes that there must be judicial review, which is to say that a judge won't take on faith other persons' view that their deeds are valid. And I would add, as Professor Tribe did, very importantly, that every governmental actor must ensure that the Constitution prevails over competing sources of law. The original interpretive community deduced a series of intergovernmental immunities. States can't tax the Bank of the United States, nor can the federal government tax the states or tell the states how to use their own powers. The entire understanding of what political sovereignty means in the United States lies in constitutional structure rather than particular clauses. Question is, what follows from this? Surely not that if some important matter depends on structure rather than text, the judges can today impute new roles to old texts. One can't say something like, well, the word liberty is extremely vague, and therefore judges can do anything they want. For that approach would negate the main feature of the actual written Constitution, that new problems are to be resolved through the institutions of a representative democracy. The phrase rule of law often goes with the phrase a government of laws and not of men, and it's helpful to remember the origin of that phrase. It comes from Article 30 of the Massachusetts Constitution of 1780, and it says, and I quote, "In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judiciary shall never exercise the legislative and executive powers, or either of them, to the end that it be a government of laws and not of men." Ask yourselves, why do federal judges have life tenure? It's surely not so that they can play the role of the guardians a la Plato's Republic. Plato hated democracy, but our Constitution embraces democracy and holds representatives on short leashes. Senators get 6 years, presidents 4, representatives 2. After all, it was the problem of non-removable people making important decisions that led to the Revolution of 1776. But tenure is a curious institution in a democracy. The Jacksonians tried to wipe it out early in the 19th century, and in some states they succeeded. Tenure's justification is, well, to enforce the rule of law. That is, to protect people from the mob and make political compromises stable. Judges with tenure can enforce freedom of speech and the rights of enemy combatants, even when they are very unpopular with a majority. A judge can try someone accused of shooting at the president without fear of removal if the judge rules for the defendant, for fear of removal would make it impossible for the defendant to get a fair trial. But tenure, like the Force in Star Wars, has a dark side. And as with the Force, the dark side is self-indulgence. Tenure frees a judge from today's passions, the better to enforce the law. And tenure also frees a judge from the law, the better to enforce his own view of wise policy. Judges sometimes yield to that temptation. It's inevitable. And it leads to a belief that judges are politicians in robes, which makes the selection process for judges more political, which leads to an increase in the probability that we will get politicians in robes, like it or not. Well, before I address the question how the dark side of tenure is best controlled by the rule of law, I want to say a few words about whether this has been a serious problem. That the press and the Senate Judiciary Committee and confirmation hearings concentrate on a few social issues, such as abortion and capital punishment. And you read much in the newspapers about 5 to 4 decisions with liberal and conservative blocs. Newspapers have even taken to identifying judges by the party that appointed them, as in, Easterbrook, a Reagan appointee. Pretty much the same way they identify senators by party, as in Durbin, D-I-L. Well, scholarly studies do show that a judge's imputed ideology matters to his voting. And it's hard to see how it could not. Judges, like others, see the world through the perspective of their lives and beliefs. That is, they have what Justice Holmes called their can't-helps. They may justly be censured when they fail to try to control the effects of those beliefs. But it's quite wrong to think that judges regularly fail in this effort at self-control. The Supreme Court chooses fewer than 100 cases every year from a menu of more than 9,000 applications. Now, you notice I've started with numbers, and at this point in this gathering, it's traditional to start projecting up there a bunch of PowerPoint slides. But you have to understand that I'm a lawyer, and therefore I'm just going to stick with words. Anyway, the cases the Supreme Court hears are the most difficult that our legal system has to offer. And yet, year in and year out, the court manages to decide about a third of them unanimously. That figure has been stable for more than 60 years, even though the size of the legal system has been growing. And the court correspondingly has become more selective. 60 years ago, the court heard roughly 1 in 5 of those cases in which the litigant sought its review. Today it's 1 in 90. That the justices agree unanimously in a large fraction of the legal system's most contentious cases shows that they do very well in elevating law over politics. I'll ask you to slice the numbers from another perspective. I want you to ask, well, I'll ask and tell you anyway, whether you ask or not. For each possible pair of justices, how often do they agree and how often do they disagree? Most pairs agree between 75 and 80% of the time. Justices who the press depicts as identical, Scalia and Thomas, for example, or Ginsburg and Breyer, turn out to disagree in about 20% of each year's cases. That disagreement has to be driven by law and not ideology. It also turns out that the highest disagreement rate between any pair of justices is 41%. That's how often Justice Thomas and Justice Ginsburg disagree. They agree on the other 59% of all cases. So what these figures are telling us is that about half of all disagreement on the Supreme Court is driven by law. The other half is driven by something that we don't yet completely understand. And we're looking only at the disagreement. There is a huge reservoir of agreement. That's where I began. And since we're looking at society's most contentious cases, the disagreement rate is very low. Judges do pretty well at enforcing a rule of law, even when the temptation to be self-indulgent is great. You read from the newspapers of 5 to 4 splits, which are perhaps 20% of the Supreme Court's docket, as if the very fact of division shows that politics must be at work. Not at all. Suppose Justice Scalia were cloned and the court populated entirely with Scalia clones. If that makes you nervous, mentally clone Justice Ginsburg with 9 Justice Ginsburgs. You might think that that court would decide all cases 9-0, but you'd be wrong. The fact that the clones were very similar would certainly change how the courts of appeals ruled in particular cases, and it would change which disputes were worth pending lawyers to take to the Supreme Court, and it would change which one of the 90 cases the Supreme Court took for decision. But an all Scalia or all Ginsburg court would find many cases that are hard for Justice Scalia or hard for Justice Ginsburg. And when ruling, this court would issue a lot of 5-4 decisions, and some 6-3, and some 7-2, and maybe 1/3, 9-0. The existence of 5-4 decisions on this hypothetical court would show not the ideology that politics controls, it would show only that in our legal system you can find hard cases. Now let's look beyond the Supreme Court. A careful study of all decisions by U.S. courts of appeals over many years concludes that the political party who appointed the president, that's something that social scientists often use as a proxy for the judge's politics. It's a bad proxy, but maybe the best one we have. Anyway, it concludes that the political party of the president who appointed the judge explains about 6% of all observed disagreement on the courts of appeals. And there's rarely any disagreement to observe. The other 94% of disagreement on the Court of Appeals comes from something else, from ambiguity in statutes, from disputes about what the facts of a particular case might show, and so on. My sense of matters, after almost 24 years of judicial service, is in accord. Genuinely ideological disagreement among judges is rare. The rule of law is by far the most powerful factor in judicial decisions. Well, what then do we make of the disagreement that remains? Some is irreducible. Some can be controlled by reminding judges that the price of tenure is tight constraint on the discretion that the actor possesses. If you can't fire the referee in a football game, you make absolutely sure that the rules are clear and controlled by somebody other than the referee. The less a person is subject to control by threat of removal, the more important it is to insist that the person use specific rather than general rules. For the more general the rule or standard, the greater role the dark side of tenure can play. Now, one consequence of this is that judges need to be very suspicious of claims that some rule has lain undiscovered for 200 years and is only now being understood. An assertion that the interpretive community at the times of a text adoption did not really understand its meaning, but that we do, is almost certain to be false. Not completely certain to be false, but very likely to be false. For as I've stressed, the meaning of a text lies not in the drafter's head, but in the way a text is understood by an interpretive community. Claims of newly discovered meaning therefore become necessarily claims of changed meaning. Another consequence is that a judge must insist on a level of certainty that is adequate to any assertion of power to have the last word. Go back to the beginning of my talk. Why is it that we have judicial review? It's because the Constitution is law, and it's a law superior to a mere statute. When the Constitution is something other than law, but just an aspiration, when rules evolve, then judges must respect the Constitution's two means for handling ongoing disagreements. One of these means is political decisions by the national government, and the other is respect for the fact that each state may choose a different solution. Robert Nozick argued in Anarchy, State, and Utopia that the best way to organize society when individual preferences differ is to allow many different solutions. We don't expect the society of California to be like the society of Maine, and indeed we may be very happy that it's not. The only requirement is that each of these solutions not impose costs on people who are not participants in the bargain made in the local jurisdiction. And that's why judges with tenure have to be exceptionally wary about enforcing what they see as a national consensus, because that contradicts the federal system that represents the heart of our national organization. So as you see, Professor Tribe and I agree on a lot, but we disagree on some things that matter. But I think the one thing you should take away from this is that the newspaper understanding of the way the rule of law is administered is very seriously flawed. Thank you very much.
I know Judge Wood has questions that she wants us to address, so I will try to be brief to make sure we do have ample time for that discussion. One of the points that Professor Tribe makes in his book is that among the list of fundamental principles that are part of the invisible Constitution, that are not rooted specifically or expressly in the text, is the rule of law. And as both Judge Wood and Professor Tribe indicated, the precise content of the idea of rule of law is not perfectly well defined, although it calls forth values like consistency, neutrality, even-handedness, nonpartisanship, following the rules and following the processes that are expected, adhering to general principles and appealing to those general principles as a source of reason and guidance and the like. And I think there's a fairly general consensus that those values are positive and they're important to our legal system and to our constitutional system. And it would be hard to get an argument these days that the rule of law is a bad thing. Now I want to comment a little bit about some of Judge Easterbrook's statements about both judges and their behavior and ideology, and second about life tenure, both insofar as they relate to the concept of rule of law. I agree with Judge Easterbrook that for the most part, indeed for the very most part, judges do follow the rule of law in the simplest sense. That is, that they do seek to be even-handed, they do seek to be neutral, they seek to be nonpartisan, they seek to follow the general principles and precedents, and the degree of agreement among judges, even judges appointed by different parties across the array of cases, is in fact very high. On the other hand, it's also true, as Judge Easterbrook noted, that there is a fairly predictable correlation between the party that appointed any particular judge, the party of the president who nominated the particular judge, and the probability of disagreement. That is, Democrats are more likely, judges appointed by Democrats are more likely to disagree with judges appointed by Republicans than they are with judges appointed by Democrats. And that's consistently demonstrated. And it's particularly acute, and here I think that looking at the entire array of cases is a bit misleading, because that effect is particularly acute when you look at highly ideological cases where the law is in fact unclear. So where judges are bringing to bear something other than either an indifference to the kind of ideological overtones of the case, some complicated commercial case where the judges may not have any strong priors, and those cases where also there's not any controlling precedent that dominates, then one does find, in fact, a fairly significant disagreement among judges that's fairly predictable along the lines of the party of the president who nominated them. But that I find actually not troubling at all. The truth is the exercise of judging involves judgment. And when the precedents are unclear, when there is not an unambiguous statute to control or to dictate an outcome, judges will bring to bear, and expected to bring to bear, their basic understandings about the role of institutions, the particular role of courts and judges, about the way in which one goes about interpreting the Constitution. And those differences do, in fact, correlate with political partisan outlooks in our society. And so I think there's nothing illegitimate about the fact that those disagreements exist. They are an inevitable product of the fact that judges do exercise judgment. Judgment does involve something other than simply sticking a question into a computer. So for the most part, I agree with Judge Easterbrook that this is not, in fact, a serious problem in our judiciary, although it's been the subject of a great deal of inquiry in recent years by scholars. Where I do disagree with Judge Easterbrook, or just as a matter of degree disagree, is on this question of life tenure. He's certainly right to say that there are dangers in the arrogance that can come with tenure, and with the notion that one is not accountable to anyone for one's decisions, and the temptation to act in a way that is lawless if one has that power, is obviously great and to be taken seriously. On the other hand, there is a reason for life tenure for judges, and it's a reason that I think is deeply rooted in the entire philosophy, the fundamental philosophy of the American constitutional system. Because although that system is based in large part on the idea of democracy and majoritarianism, it's also based on a serious recognition that majorities are not always wise or tolerant or respectful of difference or calm or level-headed, and that there are circumstances in which they will do bad things, things that are in fact incompatible with the larger values of the society. And one of the most magisterial achievements of the American Constitution, particularly as it's evolved, is recognizing that judges with life tenure are sufficiently non-accountable to prevailing majorities and hopefully sufficiently dedicated to the rule of law that they can provide a useful check on majoritarian abuse. And so although abuse of life tenure is a real concern, the absence of the role of judicial review and the absence of the capacity of judges to play the role they have played for the most part in our constitutional system, I think would be a much greater danger. Now, I want to give a couple of examples of good and bad illustrations of, in my view, the rule of law, particularly in the judicial process, but also in the executive process as well. Two good examples that occur to me. One is the tapes case, arising out of the Watergate controversy. In the tapes case, the Supreme Court held that the president was, in fact, not above the law and could be compelled to reveal tapes despite claims of presidential immunity. And what was striking about that decision is that it was agreed upon by justices from both political parties, clearly looking to some principle of rule of law, of consistency, of neutrality, that went beyond any partisan political interests that they themselves might have had, any rooting interests that might have distorted their commitment to the rule of law. And even more powerful as a result of the tapes case, of course, is that President Nixon complied with the ruling of the Supreme Court. That he could, in theory, have burned those tapes and said, be damned. And yet instead, despite the consequences to him, he in fact acted in accord with the rule of law. And although obviously disagreeing with the Supreme Court decision, understood that it was his responsibility under the Constitution to act in conformity with that decision. And that has not always happened in our country, and we should not take that act by Nixon for granted. For example, after Brown and Board of Education, many southern states specifically opposed compliance with the rule of law, arguing in effect that Brown versus Board of Education was not consistent with the rule of law. A position Nixon could easily have taken, but chose not to take. Another similar example of judges acting in conformity with the rule of law in a similar, potentially ideologically tainted case was the Paul Jones case involving President Clinton. A case, I should say, in which I was one of the lawyers representing President Clinton in the Supreme Court, and we lost 9-0. We were right, in fact, and subsequent events, I think, proved that we were right and the Supreme Court was wrong. But the fact is, despite the political party of the president who appointed those 9 justices, they all erroneously thought they understood the rule of law and reached a decision that was clearly incompatible with what some of them might have seen as their political preferences. And again, that's to the credit of the court and a good example of the justices acting in a way that was in accord with the rule of law. A more complicated example on the other side is Bush versus Gore, where I think it's fair to say that at every level of that case, from the polling officials who are holding up the ballots to look for the hanging chads, to the Florida Supreme Court, to potentially the Florida legislature, to the Supreme Court of the United States, there was very little confidence on the part of the American people that anyone was truly acting in accord with the rule of law. And I think in the case of Bush v. Gore, when the justices voted in a way that comported perfectly with what most people understood to be their political preferences, there was really good reason to believe that the rule of law was not, in fact, followed. But in defense of the court, I want to say that at the time that decision was pending, Among all of my colleagues, both at the University of Chicago and elsewhere in the academy and the legal profession, nobody I knew did not believe that the right decision in Bush v. Gore was the decision that just happened to correlate with the person they thought should be the better president. And this was really interesting because it showed the power of distortion and of bias when the law is in fact ambiguous, when there's not a controlling precedent, and more importantly, when there's not the opportunity, which I think is essential to the rule of law, for reflection. Because part of what made Bush versus Gore such a perilous decision for the court was that one of the ways judges operate is they have time to think. They don't have to decide cases instantly. They have time to deliberate, to argue, to reason, and to eventually, at their own time frame, to reach a decision that they think to be right. Bush v. Gore was unusual because the time frame was dictated not by the court's docket, but in fact by the constitutional limitations of the election process. And therefore the justices had to decide that case extremely quickly. And they therefore, I think, were not able to overcome their biases, which I think did have the same effect on them as they had on me and virtually everybody else I know. But it's a good example of a case where I think the rule of law really didn't turn out. And that's not to suggest, by the way, I think there was a right or wrong answer in Bush v. Gore. It's just that I think that the ideological disposition of the justices was the controlling feature in that case. The final example I want to give is really some of the actions of the Bush administration over the past 8 years. Now, rule of law involves not just courts, it also involves executive branch officials, as illustrated by Nixon's compliance with the Tapes case. And I think the Bush administration has repeatedly been guilty of arrogance and defiance of the rule of law in ways that are deeply troubling. And this was true, I think, not only in terms of whether the Bush administration enacted policies that were themselves directly unlawful, although I think there are examples of that, but also that it promulgated and attempted to implement those policies in secret, in circumstances where secrecy was not consistent with the rule of law, where in fact it was intended precisely for the purpose of circumventing the rule of law and avoiding accountability. And I think that the implementation by the administration of its electronic surveillance program, which was intended to be secret, of its torture memos, which were intended to be secret, were not in fact designed for the purpose of protecting the national security. That is, I'm not talking about the substantive policies, but the secrecy of the promulgation of those policies, but instead was designed to insulate the executive branch from public accountability and from the role that Congress was supposed to play, and ultimately the courts were supposed to play, in enforcing the rule of law. And indeed, when the Supreme Court finally had the opportunity to evaluate the constitutionality of many of these policies of the Bush administration, in cases like Hamdi and Rasul and Hamdan, it's interesting that its basic position in holding the actions of the Bush administration unconstitutional was not so much that the policies themselves were necessarily unconstitutional, but that they had been promulgated and implemented not in accord with the rule of law. That is, these were matters that should have been openly deliberated about, where the Congress should have played a role, and where the court should have had an open opportunity to evaluate the constitutionality. And it was the very secrecy and the unilateral nature of the decision-making that violated the principle of rule of law. Final point is, I think that Frank Easterbrook's right that the idea of rule of law is vague, it's open-ended, it doesn't have clear meaning in specific circumstances, and that's not a problem. It's a challenge. Like Congress shall make no law abridging the freedom of speech, or no person shall be deprived of life, liberty, or property without due process of law. Our Constitution is about debate and deliberation and judgment and discourse and argument and reason. And this is a process that is fundamental to the American constitutional system, and it's what makes us who we are. Thank you.
Well, I think we've promised you an interesting program, and thus far, I certainly feel that that's what we're getting. Professor Tribe, did you want to make any comments before I see he's taken many notes while the others have.
I'll try to be really brief and kind of telegraphic. With respect to these 9-0 decisions, like the one that Professor Stone mentioned, in which the court was unanimous but wrong, I can actually think of a couple of decisions that I've won 9-0, and that in retrospect, I think the court was unanimous but wrong. I think, as Frank Easterbrook pointed out, one can infer very little from either close division or unanimity, that even a court of clones would often find something with which to disagree. I want to make a comment about a couple of things that Judge Easterbrook mentioned. He talked, I think not in a complimentary way, if I detected it right, about these invisible clauses of the Constitution, discernible only to the legal elite who have read Wittgenstein and Kurt Gödel's work. That's clearly not what I have in mind, not these obscure, invisible clauses, but rather dramatic, widely agreed upon principles to which you needn't be a member of any elite to recognize. Take the principle that the states may not secede from the Union. You don't need to read Wittgenstein for that. But you won't find it written in ink in the parchment of the Constitution. You'll find it written in blood at places like Gettysburg. And the fact that many of these principles are not written down is simply the beginning, not the end of wisdom. We have to debate what they mean, the circumstances in which they're true. And I think, a final point, I think Judge Easterbrook said that the assertion that the interpretive community in 1789 or in 1868, to take the dates of ratification of most of the Constitution and of the Civil War amendments, the assertion that they didn't understand the meaning of something, but we do, is almost certainly false. But I want to be clear that that's certainly not the view of most people who believe in what they call the living Constitution. The view rather is that the meaning itself was elastic, that the people who wrote the 14th Amendment, though they expected that it would not be used to strike down racial segregation by law, meant that the subordination of one group by another through the legal system was wrong. They left open for the future the question of what would constitute such subordination. And when the court in 1954 said, we understand that the meaning of segregating people by law is the subordination of one race to another, even though they didn't seem to get that when Plessy v. Ferguson was decided. They're not saying, when they say that, we know what was meant in 1868 or in 1880 better than the folks back then did. They're rather saying that the principle that was promulgated is a principle which, by its very nature, by the very generality of the terms in which it was couched, was meant to generate something that would have evolving meaning. And so both the idea of the invisible Constitution and the idea of an evolving Constitution do not rest on the notion that some special elite, privileged to be alive today, understands what was meant earlier better than they did.
Well, Frank, I invite you to respond to that, but in your response, perhaps you might address one of the cases that, if I'm not mistaken, you were referring to, which is the recent decision of the Supreme Court in Kennedy against Louisiana, to the effect that it violates the Eighth Amendment's prohibition against cruel and unusual punishment to have the death penalty for the rape of a child when no death was involved in the incident. This was a case in which the majority of the court, for those of you who are not familiar with it, said that there was an evolving consensus in the United States that, in effect, the eye for an eye principle now exists in our law, that it is cruel and unusual punishment to impose a death penalty when there was no death.
If you want to talk about that, that's fine, but I don't want to.
That's fine. I think you did allude to it in your speech.
No, I want to make a couple of more general. I always worry when Professor Tribe or another of my friends talks about the living Constitution or the evolving Constitution, because of course the opposite of that is presumably the dead Constitution, or the extinct Constitution. If you're not evolving, you're no longer fit for duty, and so on. I think it is important not only to understand that legal principles continue to evolve. That's what democracy is for, whether or not the work is being done by the judicial branch. but that it is very important not to overstate the role of courts in bringing about security of people's liberty, life, liberty, and property, as the Fifth Amendment has it. If you look around the world, what is really important is what we generally refer to as the rule of law principle. That is, the government is conducted in a regular way, that it engages in hearings before putting you in prison, that there is an availability of review by somebody with tenure to test the application of the law to you, but not necessarily the availability of a hearing to test the validity of the law. If you look at the, say, legal systems of the United States, Canada, and France, right, the United States has the system of judicial review with which you're familiar. In Canada, there's a Supreme Court that can make constitutional decisions, but it can be overridden by Parliament. It's a notwithstanding clause of the Canadian Constitution. And in France, the legal system cannot make constitutional decisions in any law, on any law, once it's adopted. And yet, if you go to Canada or France, you'll find they have fundamentally the same liberties as we do. Not because of the details of constitutional structure, but because these are all democratic countries, and they all adhere to what I've tried to define as the basic features of the rule of law, including review of application by a tenured judiciary. One needs to be very careful not to have an insular perspective in which one assumes that the outcome in the United States is attributable to particular features of our structure of judicial review. That's not really what we observe. We observe instead a convergence of rights among the great Western democracies, even though the legal systems are fundamentally different.
Well, I would like to keep time available for comments and questions from members of the audience, and so I think we can move to that. It's the gentleman here. Are there microphones or people?
I had a two-part question for you. First of all, do you agree with the premise that the most important, or one of the most important tasks of a president is the appointment of Supreme Court justice? And the second part of the question is, if Judge John Paul Stevens does retire, what would your recommendations be?
Professor Tribe, you've written a book about this.
Well, I've written a book about it, but I'm also an informal advisor to the president-elect, so I'd rather not discuss that question at the moment. Others might.
I guess I would say that from the perspective of law professors, the appointment of justices of the Supreme Court is certainly the most important thing that the President of the United States does.
I don't think that.
Well, you don't? Okay. Well, I guess I don't think that really either. But I was trying to be funny that way. So.
I get it.
But it's obviously one of the important things that a president does, and there's no question but that if you imagine a Supreme Court consisting of 9 Antonin Scalias versus 9 William Brennans, American law would look very different over an extended period of time. And American law would look different in some very important areas. And that means American society in some areas would look quite different over an extended period of time. So I do think that it's an extremely important responsibility of the president. But also, like Professor Tribe, I have a little bit of advisory role with the president-elect, and so I want to stay away from saying anything about particular individuals. Though I can say pretty confidently that Frank wouldn't be my choice.
All right.
Particularly because I'm going to disagree with them both and say that I think it's one of the least important things a president does. For the reasons that should be evident from my most recent comment, when you get a broad convergence in personal rights and liberties across countries with very different judicial structures, very different means of appointing justices, it's hard to locate that convergence in the identities of particular people on the court. What is important is that anybody appointed to the court be an adherent of the rule of law in the sense of procedural regularity, publicly announced rules, accurate application of rules to the facts of a particular case. Those things are important. Those are what the Western democracies have in common. It's not the details of who is on the Supreme Court.
We have a dissent here.
Yeah, let me just dissent a bit from that proposition. Take a case like the decision by the court very recently that the writ of habeas corpus cannot be suspended by Congress without some adequate substitute in the absence of the very special conditions mentioned by the Constitution. It was about Guantanamo. It was the Boumediene case. And the Supreme Court, by a vote of 5-4, and an opinion by Justice Kennedy, a very frequent swinger on the court, ruled that...
I don't think you meant that.
I didn't mean it that way. Ruled that it's impermissible to create a legal black hole within which no law applies, and in which the rule of law cannot be enforced by habeas corpus, the classic great writ. Now that was 5-4. The dissents were very vigorous. One of them, by Justice Scalia, said that the majority is guilty of murder because a number of terrorists are going to go out and kill people as a result of this decision. Justice Roberts, Chief Justice Roberts, wanting to sound a bit more moderate, wrote a more moderate opinion, but joined the Scalia opinion. It was 5-4. If Justice Stevens or any of the other justices in the majority were to leave, I submit it would make a very great difference whether the president is someone who, as John McCain said during the campaign, regarded Boumediene as one of the worst decisions in the history of the United States Supreme Court, a list that includes such all-time hits as Plessy v. Ferguson, Dred Scott, Korematsu, but this was one of the worst, and in which President-elect Obama said it was one of the best decisions in the history of the court. Now, whether over the entire arc of history we would be worse off if we didn't have a system of strong judicial review is really too large a question for any of us to answer, because the path dependence of a nation which relies heavily on judicial review to protect certain basic freedoms is very different from the path that would be followed in another society. To say that France and Canada manage with very different systems isn't to say that if you ripped this feature out of our system, we'd be just fine. It's to say if you redid our history entirely, made us more French or more Canadian in many other respects, that maybe we wouldn't, on balance, be worse off. But you have to be much more of a psychic and a historian than I am to evaluate the plausibility of that proposition. And I think the burden lies on Judge Easterbrook to defend it, if that's genuinely his view.
I'll be happy to. I think Boumediene is one of the least relevant decisions in the history of the Supreme Court. Nothing turned on it. That's one reason why I hate rhetoric in judicial opinions. I don't think anybody dies because of Boumediene, nor was the dispute in that case between the rule of law and a black hole. The actual dispute in that case was whether the Detainee Treatment Act of 2006 provided procedures that were adequate substitutes for the Great Writ. The Detainee Treatment Act provides for a plethora of hearings followed eventually by review in the D.C. Circuit. Now, one can debate...
All right, there are other questions.
One can debate the details, but my bet is that there is very little different of importance between the statute and what will actually happen in the wake of Boumediene.
All right, other questions?
I have a question I'd like to direct to both Professor Tribe and Judge Easterbrook, partly because since I didn't get into Harvard, I never got a chance to ask Professor Tribe a question. And since when I argued in the Seventh Circuit, I never get to ask questions again. I wonder, isn't it a little misleading to try to discuss this question of the rule of law along the statistical lines that Judge Easterbrook laid out about how many times justices on the Supreme Court and judges on the appellate courts disagree, because it completely leaves out, or assumes rather, that presidents of the Democratic presidents will always appoint similar viewed justices, and so will Republicans. It leaves out all the nuances of the political forces of the time that may lead with centrist or less centrist judges. And in terms of Court of Appeal statistics, it seems to me, and I would like you to respond to this, most Court of Appeals judges, I think, do a very good job of following the directions of the Supreme Court. So when the Supreme Court takes a conservative turn, for example, I think courts of appeals across the country have taken a conservative turn, regardless of the particular backgrounds of the judges on those appeals. I wonder if you can comment on whether that's a correct observation.
I could comment briefly on the latter point, because it was a professor who used to be at the University of Chicago Law School and is now happily a colleague of mine, Cass Sunstein, who's done a comprehensive study of all Court of Appeals decisions since 2000, I think, and has reached the conclusion, rather distressing to him, to me, to many others, that there is an enormous correlation based on political party in areas where the Supreme Court, taking only 70 or 75 cases a year, has left substantial room for disagreement and substantial discretion. I certainly agree that there are nuances, that it's not all captured by which party nominated. I mean, Stevens is the most liberal member of the current court, appointed by a Republican. There are no Brennan-like liberals on the current court. There are big differences between Scalia and Thomas, even though they both reportedly follow a somewhat similar methodology and were both appointed by Republican presidents. And so that part I certainly agree with.
Yeah, I agree. The political party of the appointing president is historically a very rough proxy at best for what a justice will do on the court. But I certainly hope I wasn't understood as denying that there are significant disagreements. If you go through my numbers, if you go through the numbers I presented, approximately 20% of the voting on the Supreme Court can be chalked up in one way or another to something that probably aligns with what many people call ideological. That's a significant amount. The suggestion I was making is that given the fact that these are all very difficult cases, it's actually not surprising and not particularly regrettable. As for the courts of appeals, I don't think it's the case that courts of appeals either turn on a dime when the Supreme Court does, or they should. The idea that courts of appeals would construe statutes in generally liberal or conservative ways when the Supreme Court is generally liberal or conservative suggests that the Court of Appeals is not following the rule of law, because there are many statutes that were enacted from generally liberal periods. Title VII of the Civil Rights Act of 1964 is a genuinely liberal statute. And if the Supreme Court goes conservative, it doesn't mean one should turn around and do something about, trim back on Title VII. That's not honest interpretation. It might be that one could predict that certain marginal questions about that statute will get one reading rather than another. The idea that the Court of Appeals should follow the trends on the Supreme Court rather than make their best estimate of the particular statute at hand is I think, not compatible with the rule of law.
Other questions?
Yes, I have a question for Professor Tribe. In light of the rule of law, can you explain the significance of the unitary executive theory of constitutional interpretation, and also the significance of signing statements?
I think I can do it quite briefly. As to signing statements, I think they're terrific. That is, it's good for the president to give a signal to the country. It advances transparency for the president to say, I'm signing this, and it's ambiguous, and here's what I think it means. Or I'm signing it because on the whole, it doesn't merit a veto, but I can think of 3 or 4 applications in which it would be unconstitutional. It's great to know that. And even if the president's theory underlining the particular statements made in the signing statement, whether it's a formal signing statement or a statement in an interview by Charlie Rose, who cares? When the underlying theory is an extravagant view of executive power, I'd rather be warned about that in advance rather than have to confront it later. So that the suggestion by Senator Specter and others that signing statements are evil and Congress should be able to get rid of them is ludicrous, frankly. That's why President-elect Obama declined, when asked, to promise never to use signing statements. John McCain who said, I'll never use a signing statement. I think that's a mistake. The underlying theory that the president cannot be interfered with by Congress, and in fact, the president's necessarily at the top of the hierarchy when it comes to executing the law, is itself a novel, problematic theory that has never gained general acceptance, although it's certainly held by a number of people. Among its implications, if properly understood, is that John McCain was right when he said he would fire the head of the SEC, because the statutes purporting to give independence to the head of the SEC are unconstitutional. They prevent the flow of power directly to the one president we have. The whole alphabet soup of independent agencies is a violation of the unitary executive theory. Now, the theory has more nuances and more subtlety, but in the interest of having more time to answer other questions, I think I'll rest just with that.
Yes, I agree completely with Professor Tribe about signing statements. The objection is not to knowing where the president stands. Most people who objected to President Bush's signing statements objected to the substance of what he was asserting, not to the fact that he was telling people what his belief was. With respect to the unitary executive, it seems to me very important to distinguish claims made by some using that phrase that the president is above statutes. The Constitution does say that the president shall faithfully execute the law of the land, right? That's his job, faithful execution. Other people, when they say things like unitary executive, simply mean that under Article 2 of the Constitution, the president is at the top of one organization, and you can't insulate from the president people lower down in that organization. That's a much less problematic view of things. And by the way, Senator McCain is obviously right. The president can fire the head of the SEC, not for any constitutional reason, but because that's what the statute says. The statute says the president shall designate a chairman of the SEC. Any president can designate a new chairman of the SEC. The statute says that.
Can I just worry about the signing statement? And what are the ambiguities about the controversy of the signing statements? Is it merely informing the public and the Congress that this is what the president thinks the law is, and he signs on that understanding, which in itself is perfectly legitimate and valuable? Or is it essentially an assertion of authority by the president to rewrite the intended and understood meaning of the law, and to suggest that it now means something very different than Congress intended, with the right response to be to veto it, but instead to essentially rewrite it? And then the greater question was that binding? First, is the president faithfully executing the law when he signs the law into existence and bastardizes its meaning at the same time that he signs it? And then there's the question unresolved, which is, well, does a president signing statement actually bind his successor? And the answer to that, I think, is clearly no. But that was part of the controversy, I think, about the idea of signing statements.
Other questions? One more.
I'd like to follow up on Professor Stone's references to instances where an administration may have circumvented the rule of law. I know that Cass Sunstein has made certain statements about not criminalizing public service, but I'd like to get the panel's views on whether or not it would be important to prosecute instances of circumventing the rule of law by this administration in the new administration.
My own view is that public officials should be held accountable for acting in conformity with the law, and if they in fact violate the law, then there is reason to hold them accountable either through impeachment or through criminal prosecution or otherwise. On the other hand, it's important to recognize that public officials are often acting in areas where there's a great deal of ambiguity about what the law requires. And we don't want, as a matter of general policy, we don't want to have public officials so intimidated about the consequences of a subsequent administration coming in and accusing them of violating the law because they disagree as a matter of policy with the proper understanding or interpretation of the law. So I think that although it is appropriate to hold public officials accountable, that authority should be exercised with a great deal of attention to the need not to make public officials too wary of being energetic in their enforcement of their responsibilities while they have power.
Mm-hmm. I agree completely with what Jeff Stone has said, and I obviously can't talk about current circumstances because judges are not supposed to talk about pending or impending litigation. But I will give you a brief story about what happened at the end of the Ford administration when I was in the Solicitor General's office, and Edward Levy, former dean and president of the University of Chicago, who is commonly accounted one of our great attorneys general, was attorney general. It was discovered at the time that the Postal Service was opening mail that was being sent to the Soviet Union and reading the contents. It had been directed to do so by President Eisenhower about the time of the U-2 controversy, and had continued on autopilot until 1975. This was going on. Statutes had been passed both before Eisenhower's directive and later, which made this very, well, let's just say problematic. The question for Attorney General Levy was, will he ask the grand jury to indict these people who were carrying out a program established by the President of the United States and had been assured by the Department of Justice that it was valid, but probably wrongly. This was a subject of agonizing debate for Attorney General Levy, for his staff, for many others in the Justice Department. There was a widespread belief that the legal opinions validating this program were unreasonable. There was also a widespread belief that it would be very unjust to put people in jail, put ordinary people in jail, not lawyers, when they were Attorney General Levy thought that no prosecution should be brought, but before, since this was the very end of the administration, he consulted with Judge Griffin Bell, who President Carter had designated as his incoming Attorney General, and Bell agreed that no prosecution should be brought. So no prosecution was brought, but the department issued a public report, you can find this, I don't know whether it's at its website, stating its view of what the law was, why the practice was illegal, why it couldn't continue, and why any future repetition of it would be criminally prosecuted. That was the right compromise between adherence to the rule of law and protecting people's legitimate expectations. It seems to me that Attorney General was wise in that respect, as in many others.
Could I make three very brief? One, I agree with Jeff Stone. Two, I want to thank Frank Easterbrook for the story. But three, I want to say that there is at least arguably a difference between opening envelopes and waterboarding.